Thank you.
SJC-11504, Commonwealth v. Michael J. Sullivan.
All right, let's proceed. Good morning.
Good morning, Your Honors. May it please the Court, Robert Bender, Assistant District Attorney, appearing for the Commonwealth. This is the Commonwealth's appeal of the allowance of a motion for a new trial by Judge Tutman of the Superior Court. She was not the judge who tried this case. The case was tried in March of 1987, 27 years ago. Involved the death of the murder of Willie McGrath a year before, March 7th, 1986. At the conclusion of the three-week trial, the defendant was found guilty of first-degree murder. He stood trial alone. Testifying against him was Gary Grace, in whose apartment this murder took place. Testifying for him was a co-defendant, Emil Petra. And not testifying was a fourth person who was present, Stephen Anger.
Now, you say co-defendant. Was Petra on trial at that time?
I'm sorry?
Was Petra on trial at that time?
No. These are all separate proceedings.
And do we
Petra
have...
had not been convicted. He had not been tried yet at the time. Mr. Grace had reached an agreement as to plead to it being an accessory after the fact, but he had not yet been sentenced.
But not Mr. Petra, is that correct?
I'm
He had
sorry?
no deal, the other,
He
Mr.
had no
Petra.
deal? Oh, Petra was just a pretrial defendant at the time that he testified.
Right.
Anger did not testify at all.
So he's testifying in a inculpatory fashion in this other person's trial?
Which he?
Petra.
Petra, I'm sorry. Petra was liable for his statements, yes. And what he said is that he witnessed Gary Grace commit a murder.
Had Petra given a statement to...
I'm sorry?
Had Petra given a statement to police?
No, Petra had not made any statement before he took the stand.
So in essence, Petra doesn't put the defendant there, and Grace does put the defendant in Grace's apartment.
Yes. Yes. Now, the situation, if the court wishes, I can go into, this case is really a fact case, and so I want to lay out a couple of things. One is that at the time of this murder, Petra lived with the defendant, Mr. Sullivan. He stayed in his room most nights of the week. And Stephen Anger was the father and boyfriend of the defendant's sister, Kathy. And Kathy and her son, by Stephen Anger, lived in that apartment. I think technically it was her apartment, and the defendant had one bedroom there, which Petra shared with him. And his sister, Kathy, and her son lived in the other bedroom. And at the time of the crime, for a few weeks, their niece, Kim, was staying on the couch in the apartment. So I just name these people because they're really the key actors in this story as to who they are and what's going on. And so at no case, and no instance in this case, is there a question of identification. All the people who are identifying and testifying all know each other and so forth. So as it was laid out, certainly the lead issue here was, do you believe Petra or do you believe Gary Grace? And as to this, the Commonwealth gave quite a bit of reason, quite a bit of evidence, obviously, in order to make a conviction here stand. One thing that was different here about Petra had made no statements at all about what happened that night until he took the stand. And he said on the stand that he spent his time pre-trial, where he was still, and with the defendant who was still not convicted in pre-trial, in adjoining cells in the Cambridge jail where they discussed the case each night of the trial, as well as discussing it before the trial. So one of the things that the Commonwealth used to impeach Mr. Petra's testimony was that he was well familiar with the evidence that was being introduced at trial and was able to, therefore, be sure that his statement was consistent with what he thought it should be consistent with, or at least could address some of the loopholes or questions that were there. On the other hand, Gary Grace was arrested within 10 days of this crime, made a statement at that time in writing, excuse me, not in writing, it was taken by a stenographer. And then while he waited trial, about a month later, he made a long written statement that's included here in evidence also, about 15, 16 pages of longhand that he wrote out in greater detail what he said happened. His
How
testimony,
did the case against Petra conclude?
how did it conclude? He was convicted. I just don't remember if it was by plea or not. He's serving his sentence right now.
And it was for first-degree murder?
He has second-degree murder. So he's been before the parole board and been denied parole. And according to what the defendant told Judge Tutman, Petra is standing by his testimony at this time. And
Now, Mr. Pino, clearly he was found guilty based on these two competing testimonies, so we're talking now about what the new evidence is.
well, there's the new evidence, and then there's the how is it compared to what evidence was at the trial itself?
Of course. With regard to the purple jacket, I guess what we know now is that the victim's DNA was not at all on that jacket.
No, we know now that the victim's DNA was not on the cuff scrapings that were sent to the Cellmark.
Okay.
That's the only part of the jacket that was examined by Cellmark. They didn't swab the jacket. They never had the jacket. And so they know that the swabs that were sent down there, or what they call cuttings that were sent down there from the cuffs that were prepared by the state crime lab, did not have DNA, excluded the victim's DNA in what they looked at.
Was there evidence that the defendant wore that jacket on the night?
The evidence that wore that jacket came solely from Gary Grace, who said, I recognize that jacket. I think that the defendant had that jacket, and I think he had it off when he was in my apartment.
How did the Commonwealth use that testimony, though?
How did it use it? It just allowed it to be said because it was part of what Gary Grace.
Of course, but I mean,
Said.
how did it use it? Didn't it focus really a lot on the fact that the defendant was wearing the purple jacket?
No, it didn't focus on it a lot. It was mentioned in a pattern in the closing argument where, because there are two things in evidence came from the jacket, besides the fact that, not surprisingly, Gary Grace was aware of some of the clothing that his friend, the defendant, wore or could wear. One of the things that they said is that Pino had found when he did a orthotolidine test of the cuff area that he got a positive result. Now, Mr. Curran says that it's not clear that that's the kind of test that was run, but that's what the lab says was run, it's what Pino said was run, it's what Judge Tutman said was run, and I think that issue is well settled. If you read Pino was on the stand probably in total of a full day, and if you read through his testimony where he's cross-examined about this, he's very careful going through all of his testimony of saying, I found, this reacted positive for blood, or I found blood here, or I was able to identify it as human blood, or I was able to identify it as group A blood. And he would give different responses depending on what exactly he had done. What he referred to on the cuffs was blood, which was the lowest thing that he said, and he explained that this means that it could be blood. He didn't say when he said, I can't tell you when the blood got there, I can't tell you anything more about it than what I just said.
Could you refresh my recollection as to the testimony about footwear that the various players were
Yes.
wearing compared to the imprints of footwear on the victim's body?
Okay, well, this is one of the key things, and I think it's one of the things that Judge Tutman unfortunately stumbled over. And, and as to this, in this motion for new trial, this was decided on reviewing of the transcript itself and looking at the scientific reports that were handed in. There's no credibility determinations or really at issue. Nobody was disputing that Cellmark didn't get the result that it got or, test what it said that it was tested. And I would submit that this court is in the same position as Judge Tutman and should take it, I asked the court to exercise its full review, not to say, well, Judge Tutman decided the motion, we should defer to her, but to make an evaluation because you're in the same position she was in order to look at this case and decide it.
What is the usual standard to review a motion for new trial? It's abuse of discretion, is it not?
It's a matter of discretion in the sense of, weighing, if I weigh everything, seeing what the judge saw, will give her the benefit of her judgment. There is deference given to a trial judge who may have a firsthand knowledge of what the witnesses look like, obviously, being at the trial. That's not something that Judge Tutman has in this case. And Judge Tubman relied heavily on the De Benedetto case in her opinion here, which was referred back, as she knows, to Judge Mulligan, the trial judge. Judge Mulligan came back and said, this is how I saw it as a trial judge. It's a very different situation for Judge Tubman.
But try my question. If Judge Tutman had denied this motion and you were on the other side of this, would you be saying that we should be doing a de novo review of her denial of the motion for new trial, or would you say that we should uphold it unless she abused her discretion?
I'd be saying that the evidence, first of all, was handled correctly.
Okay, now try my question. I'm trying to
I
figure
am
out what
trying to
you
answer
claim
you.
to be the standard of review here. Is it abusive discretion, or is it de novo because she was not the trial judge?
Like on all motions, it's a two-part thing. First is did the judge have, what facts did the judge have in order to, base her decision on? And that's where I say that the judge has made a mistake and
Did you make any credibility determinations?
She made no credibility determinations. She just assessed, if Selmark says that I can't find DNA of the victim in this swab, that it has a certain amount of weight. And when I look at that compared to all the evidence that was introduced, I think it makes a material point for the defendant that would give me a substantial risk that, not that justice wouldn't be done, but that they would have had a substantial risk that would have an impact on the deliberations of the jury, a real impact, so that there's a reason to have a doubt. Ultimately, this court asked the motion judge to determine whether or not the justice was done. That is not something which is capable of precise determination. That's why we call it a discretionary thing. But we still look at what did the judge exercise her discretion on? Did she understand the facts of the trial thoroughly? Has this a requirement in a case like this, and in fact all motions for new trial, that she has an intimate understanding of the way the facts, not just what they are, but how they work with each other? Here we have, getting back to Judge Spina's question, a problem with the shoe evidence that came up. Now, here we have two witnesses, Kim, who saw the four people come back to the apartment shortly after the murder, and we have Gary Grace, who testifies. In fact, we have Petra himself, who testifies. According to the medical examiner, there was dress shoe imprints, heel imprints, like from a dress shoe, on one side of the victim's head, and the fatal injuries were the blunt toe, 5/8 inch wide mark, not like the other shoe, on the other side of the head, and then the blows on that side of the head produced a giant fracture around ear to ear around the
There
back
were
of the
also
skull.
sneaker imprints.
Those
weren't
are sneaker imprints is what was presented. The sneaker imprint, the mark of the sneaker, there was a sneaker imprint found on the quilt that was inside the quilt where the body of the victim was found. There was an imprint of a sneaker. Now this is important because first of all, Mr. Pino, who saw that and photographed it and sent the photograph to the FBI, said it was similar to the sneaker that we seized off the foot of Stephen Anger. And on the sneakers that he seized off the feet of Stephen Anger when he was arrested was a drop of human blood. So there were two things that came from these sneakers. One is, did it make the imprint, and it had to be during the time of the crime, inside the quilt where the body of the victim was found. And two, it had human blood, not just a blood trace. And these are a pair of sneakers. So somebody was wearing sneakers at the scene.
And was it undisputed that Anger was wearing sneakers?
Was it undisputed that he was wearing sneakers? There was no evidence to the contrary.
Okay.
I mean, all the witnesses said the same thing, except that one of the witnesses said Anger wasn't there.
So the question then is, who was wearing the dress shoes and who was wearing the work boots?
Petra said that he was wearing the dress shoes. Kim, the niece, said that he was wearing the dress shoes. And Grace said that he was wearing the dress shoes. It doesn't seem to be an issue that he was wearing the dress shoes. What he did while wearing the dress shoes was a great issue. He says he didn't kick the victim in the head 5 times like the medical examiner said. He said that he kicked him in the shoulder once when he was down on the ground after he had gotten in a fight with Gary Grace and committed the murder. If you look at this case, you'll see that what Gary Grace had to say fit how the murder occurred. It doesn't have to be accepted as to who played which role, but as far as the kind of conduct that was being done to inflict the blows, Gary Grace's testimony followed that very closely. Now, what happened is this. The defendant said that the defendant's witnesses, Kim, who testified for the Commonwealth, said that the defendant might have been wearing boots. I don't really know. Maybe he was wearing sneakers. She couldn't really remember, but he usually wore boots. Petra said he wasn't there, and he said that Gary Grace was wearing boots. So under Petra's version, nobody was wearing sneakers because he was wearing dress shoes and Gary Grace was wearing boots. And somehow someone left a sneaker print on the quilt. That is the kind of evidence, I think, that carries great weight on deciding the credibility, and not the possibility that there was blood which might have come at this time of the crime or might have come at some other time. The defendant spent an inordinate amount of time saying how unreliable an orthological identification is. Not even
Mr. Bender,
identification. It
I'm
mentions that
sorry
there's
to
blood.
interrupt you, but your time is up.
All right, thank you, Your Honors.
Morning, may it please the court. Dana Curhan from Michael Sullivan. The Commonwealth did not contest the results of the testing by either Cellmark or the state lab, or that the test results constitute newly available evidence. So the only question is whether the new evidence probably would have been a real factor in the jury's deliberations. I think you have, ordinarily, if you had two witnesses who you weighted equally, who were testifying to different accounts, any kind of physical evidence would have tremendous importance. And in this case, that was the blood. To a lesser
Mr.
extent,
Curran,
yes.
was there testimony that he wore that jacket that night?
Yes, there was. Gary Grace, when he was arrested, he said Michael Sullivan was wearing a purple jacket, and he described the jacket.
Does that mean he was wearing the jacket at the time for the entire night? That he wore it just at the beginning, took it off, then put it on later on? What does that mean?
There's no testimony that he took it off. He said, he was asked, what was he wearing for a shirt? I don't know. I don't remember.
Was there any testimony that he was not wearing it at Grace's house?
I do not recall any testimony. I reread the entire transcript. I do not recall any testimony that he ever took it off.
Did the prosecutor argue with regard to the blood on the cuff in his closing argument?
Absolutely. He mentioned that 5 times. He said, if Mike Sullivan wasn't involved in this murder, why does he have blood on both cuffs of his jacket? What was he doing, rubbing roast beef on his sleeves? And argument to that effect 5 times. He mentioned the hair twice. And I think it's significant when you look at Pino's testimony. He talks about the orthotolidine test and it being a presumptive test when he's testing the ball peen hammer, when he's testing the evidence that came in the car, or found in the car. But he never said that what the testing he performed was orthotolidine testing on the jacket. Now, when you look at his lab report, it appears that that's what he did, but the jury never heard that. All they heard was, I found blood on both cuffs of his jacket. I found a spot of blood on each cuff. And on cross-examination, he acknowledged that it was occult blood, it wasn't visible, but he also said, you know, if you wash the jacket, you would still expect to find blood.
Was there, did Petra testify that Grace was the one that was wearing the dress shoes?
No, Petrola was wearing the dress shoes. That's undisputed. So Grace, actually, when the 4 of them walked into into the apartment, Kim Sullivan said Petrola was wearing the dress shoes. Mike Sullivan was wearing work boots, which he always did. Grace and Angier were both wearing sneakers. Now, there's a little bit of, everybody sort of has a different account of what people were wearing, what kind of shoes people were wearing, but I think that is a fairly accurate portrayal of what went on. What Grace said was that Sullivan was there, and Sullivan was wearing sneakers, and he took one of the sneakers off on the way there and threw it out the window when they were driving back. Petrola then said, don't throw the other one out, you're going to get us caught. And it's not clear when he had an opportunity or if he put something on. He didn't remember what happened after that, except that when they walked in, Sullivan was wearing work boots.
Can I turn to the hair for a moment?
Hair.
The judge on addendum 29 says that the new evidence with regard to the mitochondrial DNA eliminates the victim as the source of the hair. That's what she said, but it doesn't seem as if you're saying that.
No, no, that's a mistake. What happened was she wrote it, and the original decision contained, the hair eliminates him. And, the hair really isn't terribly important in this case. It's a little bit of a factor that helps us, but it's not terribly important. What we did was we pointed that out to the judge, and she realized that it was a linguistic error, and we submitted proposed corrective language. She corrected some instances in which she said that the mitochondrial DNA testing eliminated the hair.
Okay.
I think she missed a couple.
Oh, okay, because I'm reading it from her revised.
Right, from the revised. I think she missed a couple, but I think what she was saying was the hair is inconclusive and therefore doesn't help the Commonwealth and probably helps us marginally.
But it's not quite clear how it helps you. It just says, as far as I can tell, it says nothing, that we know nothing
Well,
about the hair.
it doesn't help us very much. In the late 80s, the big scientific thing was hair analysis is going to be the new fingerprinting. And turns out it's junk science. But there was a lot of testimony about how this hair could have matched the victim, and it was similar in appearance, but it didn't have a root. It was just a hair fragment. So I don't think it made a big difference at trial. I think it made probably a little bit of a difference. But the DNA testing is inconclusive as to that. But this case really comes down to the blood.
On the cuff.
The blood on the cuff. And it's, again, as I say, all things being equal, if you had two equally credible witnesses, the presence of physical evidence in the form of the blood would have made a huge difference in this case, and that really was what convicted Mike Sullivan. But I think there are a number of reasons to really doubt the story told by Gary Grace.
Let me just back up for 1 second. You say it's key. If the prosecutor had not argued the blood on the cuff, would it still be key?
It wouldn't be as key, but I think the testimony, of Pino that there was blood on the cuffs, I think that was very important. But the prosecutor made that the centerpiece of his closing argument, and it was also mentioned in his opening. But when you look at Grace's account of what happened, he said there were 4 of us and we got in the car, and I was in the front, I was in the rear driver's seat. It's a 2-door car. He got into the rear driver's seat. There are 2 fingerprints found on the rear, on the front passenger side of the car, on the window, one with blood, one without blood, and they were both Gary Grace's fingerprints. And that was consistent with Petrola's account of what happened. How would the blood get in the back of the car? 2 ways. When they went to wash the car afterwards, they could have gone into the back seat and transferred blood from the door frame to the back. The other thing is they went and they picked up Steve Angier and Mike Sullivan on the way back to the housing project, and when they got into the car, they could have transferred the blood. But the point is that I think the evidence there supports Petrola's account. I think number 2.
What about the dress shoe heel mark on the body? Doesn't that support Grace's testimony?
Well, I mean, Petrola acknowledged that he kicked the victim.
But not in the head.
Well, he did. I think.
He said he kicked him in the shoulder.
Well, he did, but I think you can draw an inference that he probably minimized his role in this. I mean, the heel marks in the head, it's pretty clear that he kicked him, and so maybe you discount that part of the testimony. But the point is, I think in many other ways his account was the more credible one. His account also, when you look at the timeline, Petrola's account makes the most sense. The victim left the Sullivan apartment shortly before 6 o'clock. At around 6 o'clock, Petrola said he and Grace were driving back to the apartment to return Sullivan's car, and they saw the victim there. They stopped, they picked him up, they went back, and that's how it happened. Grace's account was he was in bed, and for some reason, these three guys came in with the victim at 7:30 to 8 o'clock and knocked on his door and said, "Hi, here we are. We're going to rob this guy in your apartment." Why they would choose Grace's apartment, I have no idea. Kim Sullivan testified that Michael Sullivan left the apartment sometime after the victim, at least a half hour after, because it was light out. He usually went to work, left for work between 7:45 and 8 o'clock. So I'm not sure how, there's no explanation for how the victim has left. Presumably he's going to go home or somewhere. There's no explanation about how Mike Sullivan then leaves as much as at least a half hour later, maybe an hour or two later, meets up with Steve Angier, meets up with the victim, and then they all go over to the victim's, to Grace's apartment. The timeline just doesn't make sense. You also have to look at the fact that Petrola testified a couple of weeks before his own scheduled trial date. He implicated himself in the murder, essentially cooked his goose. He had no defense after that, and made a statement clearly against penal interest. He had essentially admitted to the murder, and Grace had a deal. The evidence against, he was the first one arrested. The evidence against him was overwhelming. The quilt, the towels, everything else came from his apartment. The murder took place in his apartment. He made a statement after the police showed up, searched his apartment, found all of the blood, found all of the evidence, and said, "Boy, you're in trouble." And they did say that to him. And, the best thing for you to do is tell us what happened. And he did. But he implicated Mike Sullivan and said, "I had nothing to do with this. I didn't want to do it. I didn't get the proceeds from the robbery. I didn't do anything." Now, of course, three witnesses, including Petrola and two other witnesses, testified that he went and sold the victim's watch. So if he didn't participate in it, if he was just, "Oh, please don't do it, I'm afraid for my life," how does he get the watch? How's he selling it? Another point is in Grace's account, they're driving back, the four of them are driving back to the Sullivan apartment following the killing. They stop and buy cocaine. About an hour later, they go out and they buy more cocaine. Why are they buying cocaine if they just robbed a drug dealer and took his drugs? They now have drugs. And that is consistent with Petrola's account, which is when they got to the apartment, Gary pulled out some cocaine. So,
Of course, that was all presented to the jury. That's not new, is it?
it's not new, but when you're looking at these, when you're looking at the two competing stories told by two competing witnesses, the only plus factor on behalf of the Commonwealth is that you have physical evidence in the form of blood, and you have a witness who's we can. I won't get into Pino and his travails, but he testified unequivocally that there was blood on both cuffs of the jacket. You would expect that to happen because even under Grace's account, there's blood all over the place. Pino said he found 125 blood droplets on the victim's pants. Did all this blood spatter analysis. So, according to his testimony, Sullivan then reaches down after the beating is over, grabs his chain, lifts him up 2 to 3 feet off the ground until the chain snaps off, and grabs the chain. Now, how do you do that and not get blood all over yourself? How do you do it without getting blood on your cuffs or your sleeves? Even if he took his shirt off, which I suggest that there is no evidence that happened, but even if he took the jacket off, wouldn't you get blood on the inside of the jacket, on the cuffs, when you put the jacket back on? I mean, he would have been absolutely covered with blood. So when you look at the two competing stories, you look at the evidence probably strongly supported Petrola's testimony rather than Grace's testimony, but then you get this blood. And the prosecutor did not let that go. And I do not blame him for doing this. He's got a witness who tells him he's got blood on both cuffs of the jacket. And there it is, and it comes out 5 times in his closing statement.
Now, with regard to the motion for new trial, were Pino's problems argued as part of that motion or not?
Yes, they were.
So, but this is not an Annie Dukin situation where we're concerned that this was never done. There was no evidence that the tests were never done by Pino, and the judge certainly didn't so find.
Well, we don't know, and it really doesn't matter. I mean, it is clear that there is no blood on this jacket. I cited a lot of authorities for the fact that blood doesn't just disappear. And it doesn't disappear from 2 cuffs. So there are 2 possibilities. Maybe there's a false positive on both cuffs, which is a little bit unlikely, or maybe he gave the Commonwealth what he thought they wanted to hear.
But you can prevail, I assume, without us needing to find that.
You don't need to find that. And I think we probably have enough to decide this case.
Thank you, Mr. Cohen.
Thank you.